There's something deeply comforting about knowing a home stays in the family. Maybe it's the kitchen where you made pancakes with the grandkids, or the creaky hallway that's seen 3 generations walk through it. For many of us, our house isn't just a piece of property, it's where our story lives. And for parents or grandparents, there's often this quiet hope. When I'm gone, I want the house to stay with them. But here's the part no one talks about enough. That hope doesn't become reality by accident, in fact, more family. Homes are lost, sold, fought over, or stuck in legal limbo simply because someone missed a single legal step, one form left unsigned, one conversation never had. And suddenly, the home you meant to pass on becomes a source of stress or even heartache for the people you love most. I remember Marilyn, a kind woman from my church group. Her dad had lived in their family home for 52 years. Before he passed, he kept saying, "This house belongs to you girls." But he never put it in writing, not in a trust, not in a will. So after he passed, Marilyn and her sister found themselves in court, arguing with distant relatives and dealing with probate paperwork they didn't understand. It never should have ended up like this. She told me, and she's right, that's why today we're going to talk about how to keep that from happening to your family. If you want your home to stay in the family after you're gone, there are 5 key legal steps you need to take. Nothing complicated, but absolutely essential. These are things that protect your wishes, ease the burden on your loved ones, and make sure your home stays right where it belongs. Now, don't worry, this isn't about hiring a big-shot lawyer or understanding legal jargon. I'm going to walk you through each of these steps like we're sitting at your kitchen table, just chatting over coffee. We'll talk about trusts and wills in plain English, how a simple deed can save your kids months in court, why updating your paperwork now could save thousands later, and how one good family meeting can prevent years of confusion or disagreement. And if you've already started planning, wonderful, but even then, I'd invite you to stick around, because you might be surprised at how many people think they've covered everything, only to find out they missed one small, crucial detail. If you find this kind of practical, heart-centered advice helpful, I'd be honored if you'd give this video a thumbs up, subscribe to Vibrant Elders, and maybe share your own story or question in the comments below. We're all learning from each other here, all right? Let's get into it, starting with the one document that can make all the difference between your family inheriting the house peacefully or ending up in court. Step 1. Create a will or revocable living trust. Now, let's talk about the first, and probably the most important, step to keeping your home in the family: creating a will or a revocable living trust. I know, just hearing those words, legal documents, can make anyone's eyes glaze over. But stick with me for a moment, because this one decision can save your loved ones months of stress, confusion, and even money. Let me tell you about what happened to my neighbor. Shirley, she's 82 now, and her husband passed a few years back. They'd both always said, "The house is for the kids, we work too hard to let it go anywhere else." But here's the thing, they had a will and thought that was enough. When Shirley passed the house down in her will, her son found out it had to go through something called probate. That's the legal process the courts use to settle a person's estate. And even though everything was clearly spelled out, it took nearly 9 months and thousands of dollars in legal fees before he could actually claim ownership. The thing is, wills are helpful, but they don't avoid probate. They just tell the court what your wishes are. If your goal is to make sure your home passes to your kids or grandkids without court involvement, a revocable living trust might be the better option. Here's how it works in plain terms. A revocable trust lets you move ownership of your house and any other assets you want into a container that you still control while you're alive. You can change it anytime, but when you pass away, your named trustee, usually a trusted child or family member, can immediately carry out your wishes without having to go through court. No probate, no waiting, no public records. One of the biggest myths I hear is that trusts are only for the wealthy. That's just not true anymore. In fact, many folks living on Social Security and a pension use trusts specifically to protect modest assets like a home or family land. And it doesn't have to cost a fortune either. Depending on your state, you might be able to get one set up for under $1,000 with a local estate attorney, or even less through senior legal aid. Think of a trust like a safety net. It makes sure your wishes land exactly where you intended. Without detours, if you're not sure whether a will or trust is right for your situation, it's worth sitting down with someone who specializes in elder law. They'll walk you through your specific circumstances and help you decide which option fits best. Because at the end of the day, it's not just about paperwork, it's about peace of mind. It's about knowing that when the time comes, your family won't be left sorting through legal knots. They'll know exactly what you wanted, and that you took the steps to make it easy for them to carry on your legacy. Step 2, a DD or review. TOD, transfer on death, DE-DIF. You've already got a will or trust, or even if you're still working on one, there's another step that can make a big difference. Especially when it comes to your house, it's called a transfer on death deed, or TOD deed for short. Don't let the name scare you off, it's actually one of the simplest ways to make sure your home goes exactly where you want it to go. Without getting tangled in probate court, let me tell you about Jane. She's 76, lives in a cozy little condo she's had for nearly 30 years. Her biggest concern was making sure her daughter could inherit the place without dealing with courts or legal fees. Jane didn't have a fancy estate plan or a big bank account, but she did something incredibly smart. She went down to her county recorder's office, filled out a TOD deed form, listed her daughter as the beneficiary, and filed it. It cost her under $100, a few signatures and a notary stamp later. She had peace of mind. What the TOD deed does is simple. It tells the state that when you pass, your house should automatically transfer to the person you named on that form. No court, no waiting, and no need for lawyers to sort things out. The title just moves over, just like you intended. The best part? You keep full ownership and control of your home while you're alive. You can sell it, refinance it, or change your mind and update the TOD deed at any time. That's important because your life might change and your documents should be flexible enough to change with you now. I will say this, TOD deeds aren't available in every single state. Most do allow them, but not all. So it's important to check your state's laws either online or by calling your county recorder's office or a local legal aid group. If your state allows TOD deeds, they'll usually have a standard form you can fill out. No need to reinvent the wheel. And here's something else to keep in mind. If you've had a TOD deed in place for a while, take a minute to review it. Life happens. Maybe you listed someone who's no longer around, or maybe you want to add a second name. You can revoke or replace a TOD deed at any time by filing a new one. So if you're thinking, I want my kids to have this home, but I don't want them to get stuck in court after I'm gone, a TOD deed might be just what you need. It's fast, inexpensive, and gives you control while you're still here. Because when you care enough to plan ahead, you're giving your loved ones more than just a house. You're giving them peace, simplicity, and a little bit of calm in what might be a very emotional time. Step 3. Update joint ownership and TITLE. All right. Let's talk about something that sounds a little more complicated than it is: joint ownership and the title to your home. I know, it doesn't sound as exciting as a new kitchen remodel or planting tomatoes in the spring, but if you want to make sure your house stays in the family, this step matters more than most people realize. See, ownership isn't just about whose name is on the mailbox, it's about what happens to the property when one person passes, and depending on how your home is titled, it could either transfer smoothly or turn into a paperwork nightmare. Let me give you an example. My friend George, bless his heart, thought he was doing the right thing when he added his daughter, Amanda, to his home title. He used what's called joint tenancy with right of survivorship. That means when one owner dies, the other automatically gets the house, no probate, no fuss. Sounds perfect, right? Well, here's the twist. By putting Amanda on the title while he was alive, George made her a legal co-owner. That meant when he needed to refinance the house to fix the roof, Amanda had to sign the papers too, and because she was now an owner, her credit and her debts could affect the house. If she'd ever been sued or gone through a divorce, the house could have been dragged into that mess. That's why it's important to really understand the different ways a home can be owned jointly. There's joint tenancy with right of survivorship, which automatically passes the home to the surviving owner. There's also tenancy in common, which doesn't do that. It sends your share to your estate, not the other owner. Then there are Married couples in some states who can hold the title as tenancy by the entirety, which has even more protections. So what should you do? First, take a look at your deed. Whose names are listed? How are they connected? Joint tenants, in common or something else? If you're not sure, your local recorder's office can help, or you can ask a real estate attorney to explain it. Then think about your goals. Do you want your child to inherit the house without probate, but without giving up full control now? Then maybe a Todd deed or living trust is better than adding them directly to the title. Or maybe you want to share ownership. Now, maybe you're aging and need someone to co-manage the property. In that case, be sure you understand the tax implications. And legal risks first, it's your house. You get to choose how and when it passes on. But the key is to make sure the paperwork reflects your wishes, because if it doesn't, the state has its own ideas, and those don't always match what's best for your family. Step 4, designate beneficiary on mortgage, life insurance, and PFDYOUD. Be surprised how many people do everything right. Set up a trust, update the title, even record a Todd deed, but then forget one critical detail: who actually receives the money when something happens. That's where beneficiary designations come in, and they might sound small, but they can make or break your plan to keep the house in the family. Let me tell you about Tim. He'd been meticulous, had a will, had the house in a trust, everything lined up, but when he passed, there was a snag. His life insurance policy still listed his ex-wife as the primary beneficiary. It hadn't been updated in over 15 years. So even though his daughter was supposed to use that money to help pay off the mortgage and keep the house, the funds went somewhere else entirely. No court, no appeal, it was automatic. That's the thing with beneficiary forms. They override what's in your will. It doesn't matter what your trust says or who you verbally promised something. 2, if your paperwork still lists someone from a past chapter of your life, the system will follow that paper, not your intent. This is especially important if you have mortgage life insurance, a home equity line tied to an account, or a savings fund earmarked for property taxes or upkeep. All of those can have named beneficiaries. And if they don't, or if they're outdated, it can leave your loved ones scrambling for money they expected to receive. So how do you fix it? It's not hard. Start by making a list of every account, policy, or financial product connected in any way to your home. Then pull out the beneficiary paperwork, physical copies, online access, or call customer service if needed. Look at who's listed. If it's someone you trust and want to receive the funds, you're good. If not, request a change of beneficiary form and update it. Most companies allow you to do this online or by mail, and it's free. Also, make sure your paperwork is consistent. If your trust says one child gets the home, but your insurance names another, you could unintentionally create conflict. And don't forget to name secondary or contingent beneficiaries. If your first choice passes away before you do, and no backup is listed, the money could get tied up in probate anyway. This kind of cleanup doesn't take long, but it goes a long way. It's like checking your smoke detectors or renewing your driver's license. Just one of those quiet maintenance things that keeps everything running smoothly, because when it comes time for your family to step in and follow your wishes, they shouldn't have to guess, or worse, fight. They should be able to breathe, to grieve, and to carry on knowing everything was taken care of the way you intended. Step 5. Prepare an empowering family meeting and maintain documents. Some of the most important conversations we'll ever have don't happen with a lawyer or a bank. They happen around the kitchen table. Once the legal documents are signed, the trust is in place, the deeds and beneficiaries are updated. There's still one powerful thing left to do: talk about it with your family. I know it's not always easy. Money can be a delicate topic, and so can end-of-life planning. But I've seen what happens when folks skip this step: confusion, misunderstandings, even heartbreak between siblings who thought they were on the same page. Carol, a neighbor of mine, handled this in such a graceful way. She was 79, living in the same house her parents had built, and she wanted it to stay in the family after she was gone. So one Sunday afternoon, she invited her 3 adult children over for coffee. Nothing formal. She sat them down, pulled out a binder, and said, "I just want to walk you through what I've set up so there are no surprises later." That afternoon gave her kids clarity, peace of mind, and most of all, confidence that their mom had thought of everything. That's what this final step is all about, empowering your loved ones to carry out your wishes, not guess them. So how do you have that conversation? Start simple. Let them know you've taken legal steps to protect the house and avoid probate. Share where your key documents are stored, trust papers, the deed, any insurance policies or account info. If you've named someone to be your successor, trustee or executor, tell them, let them ask questions. You don't need to go into exact numbers or every little detail unless you want to. The point is to give them a roadmap so that when the time comes, they're not left in the dark. A short talk now can save months or even years of confusion down the road. And while you're at it, think about how your documents are stored. A waterproof folder in a fire-safe box is a great start. Some folks also upload copies to a secure cloud drive or give a trusted relative a copy. Whatever you choose, just make sure it's accessible when needed, not buried in a drawer no one thinks to open. One more thing, update things regularly. Laws change, so do family dynamics. Set a reminder once a year to glance over everything: names, addresses, account numbers. It's like tuning up your car. Keeps everything running smoothly for the road ahead. Because at the end of the day, this isn't just about legal steps. It's about love. It's about making sure the place where your memories were made stays a part of your family's future, and giving them the tools to honor that without stress, without fighting, and without fear, After talking through all of this, wills, trusts, deeds, names on documents, and family conversations, it might feel like a lot. But here's the truth. It's not about doing everything at once. It's about making sure your home, the place that's held your laughter, your holidays, your quiet mornings, and maybe even generations of family stories, is protected. And that's something deeply worth doing. Think of these 5 legal steps like a gentle roadmap. First, setting up a will or irrevocable living trust so the house doesn't get stuck in probate. Then, considering a transfer on death deed if your state allows it. An easy, low-cost way to pass your home directly to a loved one. Next, reviewing who's on the title and what kind of ownership it is, because the wrong name on a deed can create years of legal tangles later. Then making sure your mortgage protection, insurance, and related accounts have the right beneficiaries listed so money goes where it's meant to, not where it used to. And finally, gathering your loved ones for a real conversation, not just about documents, but about your hopes and intentions. Each step is a layer of protection. Together, they create peace, not just for you, but for the people you love most. I want to be very honest with you. The biggest mistake I've seen folks make isn't forgetting a form. It's waiting too long, it's putting things off because they seem complicated, or because we think we have more time. But the best time to prepare is when things are calm, when you can think clearly, when you have the power to make decisions without pressure. That's why if there's one thing you take from this video, I hope it's this. Take one small action this week. Just one. Maybe you call an attorney and ask about a trust. Maybe you pull out your home deed and check who's listed on it. Maybe you call your daughter and say, hey, I'd love to sit down soon and talk through a few things, because these aren't just legal moves, they're acts of love. They say to your family, I thought about you, I wanted to make this easier for you, and that kind of care. It echoes far beyond paperwork. If this video helped make these ideas a little clearer, I'd be truly grateful if you give it a thumbs up, subscribe to Vibrant Elders, and share your own journey in the comments. Have you started any of these steps? What's been the hardest part? You might be surprised how many others feel just like you. You've spent a lifetime building your home, your life, your legacy. These simple steps ensure it lives on, not just in memory, but indeed you have the power to make that happen. And I believe you will. So go ahead, make that call, open that file, start that conversation. This is your time to protect what matters most with wisdom, with courage, and always with love.